And so I want to bring this to an interesting study and document that came out last month from the National Association of Criminal Defense Lawyers called the Trial Penalty, their Trial Penalty Report, and its subtitle is The Sixth Amendment Right to Trial on the Verge of Extinction and How to Save It. And, we saw Paul Manafort enter a plea last week after going to trial, being acquitted of some, or mistried on some counts, convicted on others, facing a second trial. He worked out a deal with the special counsel. A lot of people are, looking at the deal and talking about how the special counsel has written it in a way that probably prevents a pardon or allows them, even if he gets a pardon, to, still go
take away all of his toys and prosecute him again.
Right. And, they're not focusing on the fact that this is what happens in so many cases, that people plead guilty. And, the stats, this document in and of itself, and for those who want to read it, it's on NACDL's website. They've put a lot of effort into it. I know they've been looking at cases over a long period of time. It's about 84 pages. Some of the font is bigger than others, so it won't take you an excessively long time to read.
Go ahead and read it.
I feel like I'm in trial.
But
trial.
I just got the supplement. I just got the supplement office report.
Yeah, okay.
It's in there somewhere.
Wait.
Here's our witnesses.
Right.
We may not call all of them.
That's hilarious.
We may not call the ones that are most relevant to your defense. But, and I think the statistics bear out both on the federal and the state side that the majority over, well in excess of 90%. And in the federal system, it's over 97% of cases end up in a guilty plea.
No. And this is the bone that I have to pick with this and with the Cato Institute's crap research on the vanishing jury trial. If you look at this, the first 5 pages, you never see the word federal mentioned. But it's all about federal court.
Correct.
As though federal court is especially important. Federal court is not especially important. In 2017, there were 76,000 criminal cases filed in federal court. There were 208,000 felonies filed in Texas the year before that.
208,000?
208,000, so 2.5 times as many. So in Texas, I pulled the numbers today because this is something that I'm passionate about. There may very well be a problem. I'm not saying there's not a problem with the jury trial. We always should try more trials. But something like 20 to 25% of cases result in Texas result in dismissal or acquittal. Of the people who don't waive a jury trial, well, 23% of people don't waive a jury trial. That's the heart of the number here.
Yeah.
Right? Now, not waiving a jury trial, some of them get their cases dismissed. A whole lot of them do. Every case that's dismissed is somebody who refused to waive a jury trial, right?
Right.
Yeah.
Because if they'd waived a jury trial, the case would never have been dismissed.
Right.
1,800 people convicted, 534 acquitted, 45,000 dismissed. You've got to look at those dismissed because that's a lawyer and a client who are making the decision: do we plead guilty or do we hold fast? They hold fast, and the case goes away.
Well,
so,
but don't you think there's a difference? Because on the state side, they have. Look, let's be honest, they have terrible intake for the most part, and so pretty much anything comes in and it's evaluated later. On the federal side, they have a much more stringent evaluation on the front end, and so there's not nearly as many dismissals in federal court as there are percentage-wise.
And also the problems in this paper are absolutely true of federal court. What I take issue with is people saying, oh, this is the problem that we need to deal with, when there are probably bigger problems in state court. For example, deferred adjudication probation. People take deferred adjudication probation all over the place. 1/4 of felony cases ended in deferred adjudication probation.
Avoid the felony. Avoid the conviction.
Avoid the conviction, except that in that same year, about half of the people who were on probation got their probation revoked. There were about 30,000 motions to revoke and about 60,000 people put on probation. So if you get put on probation and there's a 50% chance that you're going to be revoked, that's not avoiding the felony.
Is that because of a shortcoming in the criminal justice system? And what would they be?
Well, and the problem on deferred too is you're still open to the full range of punishment upon returning.
I'm going to blame the criminal defense bar for that one. I think that there are a lot of lawyers in the criminal defense bar who see deferred as avoiding the felony.
But the penalty for exercising their constitutional rights is simply just too high of a risk, according to this study.
Well, and in federal court, I think that's absolutely true. In state court, I don't think that's true. I think a lot of, half of the people who took probation would probably have been better off going to trial.
I agree with you, because we're getting prosecutors down there who are setting trials without even looking or reviewing at the evidence, both at the misdemeanor level and at the felony level. They are they're overworked, understaffed, and what's happening are these judges pushing their dockets, and we end up at a pre-trial, trial, or plea setting, and they set it for the mere purpose of not looking bad to their superiors. So they'll set it. They'll set the thing, and they'll say, "Oh, this case looks good. Yeah, no, we're fine, Judge. We'll offer 2-year deferred right now." And they haven't looked at the video. They haven't done their rip calls. They haven't done anything. So the client is faced with going to these trials without even the other side doing their job.